elsewhere to resolve an investment dispute. And the International Center for Settlement of Investment Disputes in Vienna has very high standard in their rules which protect investors. And it's those standards, even when we want to formulate our own rules here of arbitration, we should be aiming at. You have the UNCITRAL rules, United Nations rules for dispute resolutions. You also have the International Chamber of Commerce rules. There are so many rules around that, but we must decide as a nation where we want to fit into all of these things. The climate is important.
All right, I'd like you to hold your thoughts there. We'll take a short break. Well, we'll take a short break now. And when we return, we'll continue with that discussion. We're looking at commercial dispute resolution implications for investment in Nigeria. Do stay with us. Well, welcome back. If you've just joined us, you're watching Business Morning on Channels Television. Well, a quick look at the financial report of Studio Press PLC. The company has reported a huge drop on its profit for the year ended December 31, 2012, from 149.7 million naira it made in 2011 to 2.4 million naira in 2012. Now, in a filing to the Nigerian Stock Exchange last week, the company's result shows 11.3% drop on its revenue for the year, and a gross profit of 1.11 billion naira is against 1.14 billion naira in 2011. The company's total assets also dropped by 13.1% to close the year at 7.4 billion naira. Studio Press is listed on the packaging sector of the Nigerian Stock Exchange. Well, I take you back to that discussion with Mr. George Etomi. We're looking at commercial dispute resolution implications for investment in Nigeria. Thank you very much for staying on.
Thank you.
Yeah, just before we went on break, you talked about President's visit to China.
Sure.
Of course, they went to woo investors into the country. Now, what are the possible areas of commercial disputes investors should actually look out for?
Well, the areas are as myriad as the sectors you want to invest in. Oil and gas, construction, telecommunications, all the commanding heights of most of the economies. And the reason why it's so important that we should have robust dispute resolution mechanism in these areas is the highly sensitive nature of the funding that's required. The longer it takes for commercial disputes to be resolved in any particular sector, the less attractive that sector is for investment, no matter what the potentials are. And as I mentioned earlier, the government in itself, because one way you can also import arbitration is through your local laws, it's doing its best. For example, in one of the incentives to the Nigerian LNG company, the fiscal incentive package, I'm sure you recall this dispute with Nemasa and all that. That was by law, and that's the law the company always brandishes when it has a problem and say, look, we were guaranteed this. You must be gentlemen, you must be honorable, you should respect those laws. So the government does that from sector to sector. However, as I mentioned earlier, there are still certain aspects of our arbitration profile that need to be tailored to meet the international standard if we're going to continue this march towards making Nigeria a favorable destination. There are some of our laws. Take the privatization and commercial enterprises law that I talked about, which provides for an arbitration panel. Now, in my opinion, the moment you begin to go that far to talk about a panel and go, you remove one of the essential ingredients of arbitration, which is the freedom of the parties to choose. Yeah. No, yes, we agree that in disputes involving a BP and go, you seek to resolve it very speedily. But you don't go ahead to predetermine the panel and say that there must be a panel. So things like that we should look at. And the reason I say that is that that came up in the recent privatization of power sector that's going on. And if you look at the plethora of agreements in that sector, there's just this one part of it, the performance agreement, which deals with and says that disputes arising from there should be resolved in accordance with this particular provision. It sticks out like a sore thumb. Now, the other aspect of it is, I don't know if you're aware that there's a bill before the National Assembly which seeks to, I think it's called the National Alternative Dispute Resolution Regulatory Commission. The bill seeks to set up a commission to regulate arbitration. Now, that, in my opinion, should not see the light of day. It's a complete no-no.
Why?
Again, the essential ingredient of arbitration is the freedom of the parties to choose. Okay. When you set up a regulatory commission, you begin to impose another set of bureaucratic controls. They're going to have offices all over the place. They're going to choose certain personnel for certain things. It's an absolute waste of money. It's a negation, in fact, of all the gains we have made. And I know there are signatures being signed by the Nigerian Bar Association and other learned practitioners of arbitration that this should not go. Now, let me make one essential point. When we talk about arbitrations, we talk about panels, they don't have to be lawyers. They don't have to be lawyers. Anybody can be an arbitrator. You don't even have to have gotten formal knowledge in the area. It's an advantage, but you don't have to have. If you're an expert in a particular place, in a particular area, you can actually be nominated.
Okay, so but how do you deal with a situation where a judge is not knowledgeable about an industry dispute or the issue? Yeah. Do you have such situations?
Yeah, we do, and this is why I was saying that that's one of the importance of arbitration, because when you have, for example, a dispute in the construction industry, you do well to have a quantity surveyor, an architect, somebody who deals on a daily basis in that area to be on such a panel. Well, you can always have a judge, not a serving judge, because a serving judge cannot also sit in arbitration and all that, retired. There are so many arbitrators and there are so many arbitration schools that you can go to. They can be there to guide on the law. Finance, you'll be wise to get finance experts so that they give you quality consideration of the disputes at stake, and so that it doesn't waste time. So you don't want anybody who's going to learn on the job. It's too expensive to do that. So those are the sort of things we should be looking at. Okay. So it's a continuous process of learning, and we must continue to learn. So
in all of these, what would be your advice to the federal government on how to deal with commercial disputes?
Making Nigeria a favorite destination. That's the way I would like to put it. It's just based on all we've been discussing. I have said, and it bears repeating, to say that bill under consideration. I think this is a direct plea to our legislators. They should have a deeper look at it. It's going to erode the independence of the arbitral process, and it's simply just going to take Nigeria way back on the ladder. We're trying hard to climb. This is just going to take us back. We have to build capacity. both an expertise, as I mentioned to you. Even though I say you don't have to be formally trained to become an arbitrator, you just need to have integrity and know the subject matter. You can be nominated by any of the parties. And just a little word on nomination of parties. One mistake that's often made is when you have a panel of, say, 3 arbitrators, and each party chooses one, and both can choose the third person who then becomes the chairman, or if they disagree, it can be appointed by any other method they choose. Those arbitrators should understand that the moment they agree to become arbitrators, they are not arbitrators for the party that chose them. They are arbitrators for the matter. Because one of the things that often leads to difficulties is because you feel you've been chosen by one party, you must go there and do their bidding. Arbitration doesn't work and should not work like that.
All right, thank you very much
and then
for
parallel. Don't have court cases and have arbitration running parallel.
All right, thank you very much for sharing your thoughts with us.